Scott.
Hey, how's it going?
Do you feel like you're reliving this again and again every time you have to come here?
Oh, for sure, for sure. You know, at least one thing the DA's office did make reference to the family and the law enforcement and having to keep reliving, going through it, you know, and even the judge did. So I hope that they'll indicated the 60 days. So hopefully, you know, I've hung on 14 years. I got to hang on 60 more days for my kid. So
How do you feel about the judge's statement that he wants certainty before finality on this?
well, he also said he hasn't heard the whole testimonies and all, and I've lived it for 14 years, and you know, even seen the ligature on my kid's neck and all the other evidence that has been presented. There's not one doubt in my mind about certainty that, you know, Swearingen murdered my daughter, and you know, and I feel for his mom. You know, I mean, we're both losing a kid. And so.
It must be just horribly frustrating, though.
Oh, it is. You know, not understanding the judicial system, and it's obvious the judge and the lawyers. There's question about, you know, the mechanics of the judicial system. So if they can't figure it out, I sure can't. But I have to know there's going to be justice for Melissa. You know, eventually, this lifetime and the next.
Thank you.
No, actually, I'm a friend of his.
Okay, how disappointed are you with the judge's decision?
Well, we're disappointed for the family and for the law enforcement, but bottom line is that the District Attorney of Montgomery County wanted DNA testing. We don't believe that they're entitled to DNA testing under Chapter 64 as the defense thinks. We wanted to get them testing immediately, tomorrow, the next day, as soon as possible, so that we can put this case to rest for everybody.
So what is the timeline on the testing now?
Well, now unfortunately there is no timeline. We have 60 days to file a motion for the response to the Chapter 64 motion, and that hearing will be held within 2 to 3 months of today's date.
Can you kind of lay out what the judge did rule and then interpret it, I guess, in layman's terms?
Yeah, there were 2 rulings that the judge made today. We asked that the evidence get sent up to the lab that the defense chose immediately for immediate DNA testing. And that's because we want those results as soon as possible. The judge declined to allow us to send the DNA or the items of evidence up there for DNA testing, so that's going to be delayed now. The other ruling that the judge decided on was that he was going to stop the execution. The execution was set for February the 27th. The judge has vacated that order, so currently there is no execution date set. Now, the position of the district attorney, Mr. Ligon, was that we want to do DNA testing in this case. We want those results, and we want them as fast as possible. The Court of Criminal Appeals has held that the defense is not entitled to any of this DNA testing that they're asked for, and that's the highest court in the state of Texas. So the defense, ironically today, may have shot themselves in the foot for DNA testing. We're open to working with the defense to get DNA testing, to do DNA testing, and to do it as fast as possible. We want the DNA testing done, and that is our primary goal. But if we can't get the defense to agree to allow us to do the DNA testing, then we're going to have to go through the regular mechanisms that the court has put in place.
Now, the fact that there's the new law that was, or the 64 was amended by legislature, does that overrule what the Court of Criminal Appeals ruled in 2010?
The amendments to the statute, which took place in 2011, have no effect on this case whatsoever. The issues that we spoke about today, the issues we're going to be talking about in the future, have nothing to do with the legal changes. The ruling of the Court of Criminal Appeals still stands, and it's still good, and that's why we wanted to do expedited testing immediately in this particular case.
Can you appeal this ruling to the CCA?
There is an appeal mechanism for this, but that would just delay things further. If we were to appeal this ruling today, that would cause more unnecessary delays for the family and for law enforcement than want closure. So we're not going to appeal. We're going to go by the judge's ruling and his timetable, and when we have that Chapter 64 motion about DNA testing on the defense delayed schedule, that's what we're going to be litigating.
Did I hear about a time frame as far as the hearing?
There is no time frame for the hearing. We have 60 days from today to respond. We'll have our response filed immediately because we want to get this case closed and taken care of as soon as possible.
And why weren't all those items tested for DNA originally, as they were saying? That's what the defense is saying.
The items were not tested earlier because the prosecutors decided that there was sufficient evidence in this case. The appellate courts, the trial courts ruled that there was sufficient evidence and no DNA testing was needed. In fact, the defense also didn't request DNA testing with those items because they were not of particular note to the defense either.
Mr. Hilder upstairs just told us that he's convinced that Swearingen is innocent. What's your thoughts on that?
Mr. Swearingen is probably the most guilty person in the history of Montgomery County when it comes to capital murder and the death penalty. The courts have ruled on it over and over and over again, and this ruling today doesn't do anything to rebut that. The Innocence Project that's what they're going to say for everybody that they represent. They're boutique lawyers that come down to Texas and try to litigate on our cases, and that is proof positive that they're interested in nothing but delay in this sort of a case.
What about the judge's change? At first he was asking wait till Friday once motions filed and then backed off of that and just made decisions so quick.
I really can't comment on what the judge's ruling was or why he decided to change his mind in this particular case. That's up to him. We accept his ruling, we honor his ruling, and we will litigate it at the next step, which is a delayed Chapter 64 hearing.
Now, what was the August 28th that he was talking about?
Since the judge vacated the execution date, we asked for another execution date to be set. The defense attorneys said that they can get all of their testing, all of their delayed testing done within 2 months. So we played cautious and we asked the judge to set an execution date 6 months out, but he declined to do that.
So right now, no timeline on an execution date and no timeline on a DNA test.
After this ruling today, there is no protocol in place for DNA testing, and there is no protocol in place for an execution. The whole case is up in limbo right now until we can have that litigation on the defense request for delayed testing. And the irony of the situation is that the Innocence Project came in and asked for testing with a particular scientist and with a particular laboratory, and we agreed to that. Not only did we agree to that, we said that we would get it done within a week. And the only conclusion that I can form as a result of their opposition to our request for immediate testing is that this is a stall tactic. And the Court of Criminal Appeals has held that these defense attorneys are the kings of stalling, and that's what they've been doing, and that's what they did today. So unfortunately for the family, there will be some more delays, but we will work with the court, we will work with the defense to make sure that DNA testing does get done in this particular case as soon as possible.
Now, they filed a motion for six separate items on that DNA testing. Can they turn around and come back later on with, hey, now we need another 6 items tested?
The defense filed a request for DNA testing on 6 items. Those items were already denied by both this court and the Court of Criminal Appeals in 2010. So they cannot come back, it's our position, and ask for DNA testing on these particular items under Chapter 64. If there are any other items that are out there that nobody's aware of, then they can ask for Chapter 64 testing on those particular items.
Now, the 6 items they want tested now, what is it? Are those the items you're talking about giving them, or what?
The 6 items that the defense requested for DNA testing, those are the exact 6 items that we propose to submit to their lab for immediate testing. We agreed to everything that they wanted to do, and we wanted to do it immediately and as fast as possible. It was the defense that stalled and delayed.
Well, a little bit about the DNA testing, the time frame. I mean, everyone thinks it takes some time. Everything, it's like you mentioned the courtroom, it's a cost factor. I mean, you pay for it, you can get it in one day.
DNA testing is a complicated process, but there are many companies and many government agencies that do DNA testing. DNA testing can be done in one day, can be done in 24 hours, and results can be obtained. We've offered to pay for that sort of testing. The reason that there's a delay in DNA testing with crime labs is because of the quantity of work that they're given by police agencies and by defense attorneys. That's why there's a 6-month to a 1-year delay in ordinary DNA testing. But if you pay for DNA testing and you want to jump to the front of the line, you can do that. And we asked for a fast pass for this particular item and for these items, but the judge denied that, and the defense did not want fast-track DNA. They want the slow route.
Even though they're using their lab that they requested and their doctor, their scientists that they requested.
It's astonishing to me that the defense attorney asked for a particular lab, a particular scientist, and a particular method, and particular DNA tests. We agreed to all of that, and as soon as we agreed to do what they wanted, immediately they objected.
But the judge ruled, did not rule in your favor. The bottom line is, that is the bottom line, is it not?
What this judge said today is the bottom line, and that is that this case is now in limbo until we have a Chapter 64 hearing. The judge ruled, he denied our request for immediate DNA testing, so there will be no DNA testing as a result of this ruling today until we have another hearing.
So what would be handled at the 64 hearing, whenever that is? You'll go over what?
We agreed to test anything and everything that the defense wants. Now, because it's a Chapter 64 hearing, we are very limited, and the defense is very limited in their requests to these particular items. They cannot come back and re-raise issues and request for additional items to be tested because the courts have said that you get one shot at a Chapter 64 DNA motion, and the defense has already had it. And we plan on holding them to, we plan on holding their feet to the fire when it comes to that.
So in other words, they may not even be able to get tested, these 6 items tested.
That is a distinct possibility that as a result of the ruling today, there may never be additional DNA testing in this case.
Can the judge change that? Can he make a ruling to let the testing continue?
The law doesn't allow for this judge to make a ruling on this particular case about the results of the DNA testing and what would happen on the case. That's all up to the Court of Criminal Appeals. All this judge can do is make an order to test these 6 items, but unfortunately the Court of Criminal Appeals, in our opinion, has already ruled on that and said the defense is not entitled to this testing under this chapter.